Hello, everyone. In this podcast, we will be discussing sensitive topics such as sexual assault. It's important to take care of yourself while listening. Some suggestions are listening while you're in a healthy headspace or knowing who you can reach out to if you become upset. Our 24/7 helpline for crisis calls based out of Central Florida is 407-500-HEAL. By contacting the national hotline at 1-800-656-4673, you can get support and learn about your local resources. There's always someone ready to help. Welcome to the Victim Service Center podcast. Here we sit down with professionals that serve survivors and victims of trauma or those who've experienced violence and have conversations about social issues. This week, we are talking about sexual assault in the justice system. My name is Emilie Mitchell. My pronouns are she, her, and I am the education coordinator at the Victim Service Center. With me today, I have Jenny Rossman. Jenny uses she, her pronouns and has been the head of the sex crimes unit at the state attorney's office in Orange and Osceola County since 2017. She was also a sex crimes prosecutor in Miami-Dade County, and Jenny and her unit work closely with law enforcement and various community partners to achieve justice for victims and keep the community safe. So Jenny, thank you so much for being here today.
Thank you for having me, Emilie. I'm really excited to chat with you today.
Me too. I'm so excited. And I also actually have returning JoEllen Revell, who's been returning a lot on the podcast. JoEllen uses she, her pronouns and is the Victim Service Center program director who oversees the advocacy, the forensic nursing department. So you can see why she comes back on a lot, because she has a lot of information to share. She is a licensed clinical social worker with over 20 years experience in clinical and administrative oversight. So thank you, JoEllen, for being a trooper and always coming back onto the podcast.
Well, thanks for having me. It's always a pleasure to talk with you, Emilie, and definitely to have Jenny join us for our first podcast with her. Hopefully there'll be more to come.
Absolutely. I'm really excited to have this really important discussion with you both, because today we are discussing what sexual assault victims and survivors can expect when pursuing sex crime charges. We'll be covering how a victim advocate can help a victim pursuing criminal justice. And we'll also take a hard look at the current realities of sexual assaults and the criminal justice system. So with that in mind, I want to just start off with kind of defining some terms here. So sex crime sounds like an umbrella term. Could you define what a sex crime is and what crimes fall under it?
Sure. So I think to start, sex crimes are different than the other crimes in the criminal justice system. I think because they involve a lot of emotions, kind of a range of emotions. The perpetrator and the victim could have also had a prior relationship and one of trust, so there might be that violation. And then obviously they involve sex, which of course is something that takes place consensually between adults. And so then to kind of define what a sex crime is in the state of Florida. So in Florida, it's called a sexual battery. That's the term for what is commonly referred to as rape. And really, it's sex without consent. So first, I'll kind of define what the legal definition is for what constitutes the sexual activity. So that is when a person's sexual organ has contact with or penetrates the sexual organ, mouth, or anus of another person. And also if an object penetrates the sexual organ, mouth, or anus of another person. And if that act or any of those acts takes place without the consent of one of the people involved, then it is criminalized. So in talking about kind of the consent element, that's what criminalizes the sexual activity. Like you said, Emilie, it's kind of this umbrella, and Florida, which I hope every other state is the same in terms of how they structure their kind of rape laws or sexual battery laws, that Florida is an affirmative consent state. And so that means that a person must affirmatively consent to sex. And that's not to say that there has to be like a contract where both people like sign, yes, we are in agreement to do this, but from the circumstances, the consent that's given has to be knowing, intelligent, and voluntary. And that's important. And on the flip side, it's not like there is an obligation on a person to say no if the sex is not consensual. It's that there has to be affirmative consent. So that's kind of the umbrella of a sexual battery. And then from there are more serious levels of sexual battery offenses in Florida based on other things that might clearly kind of vitiate any consent, like if coercion was used, or force or threat, or someone has a weapon that's actually used. And then also if a person is unconscious or is physically incapacitated. And those kind of additional factors would all make for a more serious crime than the sexual battery offense, which is already a serious crime in Florida. All of those would be felonies, just different degrees. And then the age of a person is another area of criminalization as well. So in the context of child sexual abuse cases, consent isn't really part of the analysis. It's just if a person has sex with a child, then that is a crime.
You mentioned a couple of things there as far as the definition. So, for example, a sex organ penetrating someone's mouth, anus, or other sex organ. For those individuals who have a penis, for example, and they're forced to penetrate, is that included in the definition of sexual battery?
Yes, it is.
Okay, just wanted to make that clear. And also, this definition of sexual battery, it sounds like it might differ from state to state. Is that correct?
Yeah, I mean, I think generally the way that states define the kind of what constitutes the sexual activity is pretty similar. And then the non-consent is also pretty similar. I'm not sure if there are any states left that would say that a victim had to say, no, I haven't done like a survey. I'm hoping not, that all states would require actual consent, affirmative consent, knowing, intelligent, voluntary consent from the victim to engage in sexual activity. I think that there's probably a lot of variance state to state in terms of how serious the penalties are for sexual battery offenses or rape offenses. In Florida, they are all felonies. They're serious offenses. In other states, I think they kind of vary.
Got it. Thank you so much for breaking all that down. I really appreciate that.
Actually, I had a clarifying question for Jenny. I was curious, would the idea of coercion, like where it wasn't necessarily a physical weapon like a gun or a knife, But the idea that maybe there's a threat or intimidation, like blackmail and or like, I'm going to post your, photos, would that be considered force?
So, it's kind of a case by case analysis, like on our end when we're determining what the appropriate charge is. But there's kind of definitions of what a threat is in the law, but certainly that kind of threat makes that act non-consensual, because the way that consent is defined in the law is kind of knowing, intelligent, and voluntary consent. And that would completely vitiate it being voluntary if somebody's being blackmailed or threatened in any way.
Great question. Thanks for defining that too. As we move forward in this conversation, there's a lot of legal terminology, I think, that'll be coming up. So I think it would be beneficial to define some of those terms. So could you explain or define things like confrontation clause, beyond a reasonable doubt, impact statements, and anything else that you think would be really important for our audience to understand as we move forward?
Yeah, so I'm happy to, Emilie. So the confrontation clause comes from the Sixth Amendment in our Bill of Rights from 1770 or 80, whatever year that was passed. I'm not up on my history, but we've all seen Hamilton, so that says that a person accused of a crime has the right to be confronted by the witnesses against them. And, I kind of have actually said this to victims on cases that, when the founding fathers enacted that, they probably weren't thinking about this category of victim, because, there is a degree of re-traumatization to have to come into court and testify about a sexual assault, however many feet away from the perpetrator who's sitting next to their attorney at counsel table. Well, a victim is in the witness stand in a courtroom. And, built into that confrontation clause is this right to cross-examine the witnesses. And so, the prosecutor is going to ask questions about what happened so that the jury hears from the victim about the assault, but the defendant's attorney has the right, the defendant has the right through their attorney to challenge what the victim is saying. And that's just built into our Constitution. And it's, the reason why, a victim is assaulted and then they give a sworn statement to a detective, and maybe they feel like, okay, I did what I need to do. And the reality is, if the case is going to be charged and ultimately go to trial, there are other steps that first resuscitation of what happened isn't the end of it. And so I guess that's something important for people to know. And the beyond a reasonable doubt that you mentioned, so that's the standard, the burden of proof in a criminal case. So for a jury to convict, to find someone charged with a crime guilty of that crime, this is the same in sex crimes, in every criminal case, in a DUI, in a robbery, in a murder, that's the burden of proof. So the state has the burden of proof. The state has to prove the case to a jury. So the state is putting on evidence and calling witnesses to tell what happened. And that beyond a reasonable doubt is a really high burden. You can't put a numerical number, but it's the highest burden. Like if there's a civil case and people are in a disagreement over money, that's a preponderance of evidence. That's 51%. This is much higher than that. And so it really impacts the work that we do, because we have to be evaluating a case and say, can we prove this case beyond a reasonable doubt? And then you asked about impact statements. Victims have a right to make an impact statement at the conclusion of a case when either a defendant is going to plead to the charges or is convicted at trial. And so it happens at the sentencing. and it's an opportunity for the victim, and this is a constitutional right and it's a statutory right, and it's an opportunity for the victim to talk about how the crime has impacted their lives. And so that, the defendant will hear this and the judge will hear this. And so it's kind of an opportunity to share all of the ways that the crime and the process of being involved in the prosecution has affected that person. Maybe there's one other term that would be helpful for people to know, which is depositions. And so depositions take place in criminal cases. It's something we kind of might think about in the civil context, because not every state has criminal depositions. But that is an opportunity for the attorneys to ask questions of all witnesses. So the defense attorney would get the opportunity to ask questions of the victim in a sexual assault case on the record. So a court reporter would be transcribing what is said, and it's a sworn statement as well. It's sworn testimony. It's done in an office. There is no judge present. It's the attorneys and a court reporter and the victim, but the victim has a right to have a victim advocate present. And I'll let JoEllen talk a little bit about that. But the defendant is not present for that, which is important. But it is, I talk often with victims about the kind of two major points where their involvement is necessary, and generally a deposition, and if there's a trial, testifying at trial. Those are kind of the two times that a victim could expect to have to give testimony.
That's really helpful, I think, as we move forward in this conversation. JoEllen, I have heard the term victim-centered approach as it pertains to the justice system. So what exactly does this mean? And can the VSC help a survivor find a victim-centered attorney?
Okay, so good question. Definitely a two-part question that I want to tackle the first part. So a victim-centered approach basically is intended to minimize any re-traumatization that the criminal justice proceedings and that process could bring upon to the victim. So how does that happen? It happens by being supportive of the victim, providing victims with opportunity to have access to victim advocates, whether they're court advocates or rape crisis center advocates. Those are important, and they work hand in hand to support the victim in various ways. And also, most importantly, a victim-centered approach sees the survivor as an active participant in the process, and it provides this opportunity to be empowered during the process, to be aware of what's going on, and to have access and opportunity to kind of discuss certain things or bring up certain points. I think, for an example, as part of Florida's victim rights, victims do have an opportunity to be made aware of case decisions that are happening and be made aware of things like a plea bargain or a plea agreement being kind of discussed. That doesn't mean the victim gets to decide what's going to happen with that, but they're able to be aware that that process is undergoing. Having an attorney that's victim-centered, how can we do that? Well, here's the thing about it. In a criminal justice case, the prosecution is working for the state. And so it's the state that is bringing these charges. Ultimately, the victim, it becomes a witness for the prosecution. So I really need to kind of emphasize that when we work with our state attorney office partners, and I trust that in the hiring process, the recruitment process, and the training process, individuals who are assigned to certain units, whether it be DV or sexual violence, that they would have interest, passion, training, experience in working with those victims, because that would allow an attorney to be more victim-centered. I think amongst the system that we work with locally, because we have a sexual assault response team known as a SART, and we do our best to come together at least quarterly and more often through, phone calls and emails and Zoom meetings to kind of talk about issues that are present and locally impacting our victims. I think those collaborations provide opportunity for partners, all of them, to have a more victim-centered lens. And then, there are things that are probably likely expected as it relates to training of attorneys. Just the idea that an attorney may be more informed about the neurobiology of trauma, and just kind of understanding that briefly could provide a great deal of insight into why the victim who they're trying to assist may have a behavior or emotion about something that if they hadn't learned about that, they wouldn't understand and know. So finding an attorney is not something we would do for the criminal justice system, but if there was a civil issue, we as Victim Service Center may be able to connect our clients with individuals who may have an expertise, who may have a particular focus or specialty in working with certain victims or groups of individuals, and make those connections. And I think for us, you get to know what attorneys do certain work. We have the fortune of working under a grant with the Florida Council Against Sexual Violence. And so that provides us access to attorneys through their system for our sexual violence victims. So if a sexual violence victim had a family court matter or a tenant issue or an immigration issue that impacted their sexual violence case, or their sexual assault was impacting that issue, we can use the attorneys to help them navigate through that process, and at zero cost, and it's very specialized. So ultimately, I think it's important to know that locally, I think the partners that we work with for the most part do their best to be victim-centered, but sometimes agencies like the Victim Service Center need to kind of be a liaison with the victim and just kind of provide guidance, support, and information and options. I hope that answered your question.
Definitely. Thank you so much. That really helps break it down in terms of what exactly a victim-centered approach means and a survivor-focused approach means. So I really appreciate that. Jenny, as the chief of sex crimes at the state attorney's office, what should a victim of a sex crime expect should they decide to go through the justice system? I know we started talking a little bit about that, but I was hoping you could give our listeners some more insight on that.
Sure. I guess I'll start off with kind of aspirationally what I expect for them and what I hope, because as JoEllen said, I think within our circuit in Orange and Osceola counties, we have a sexual assault response team that is comprised of law enforcement and my office and the Victim Service Center and other community partners, and we work really hard to all do our job as best as we possibly can, and we obviously are all committed to helping victims of sexual assault, or we wouldn't have chosen this career. And so, I think an expectation is that when, from the moment that a victim reports, the first person that they meet with from law enforcement, that all the way up through who they meet with at the Victim Service Center, who, they meet with at my office, the prosecutor and victim advocate, to dealing with the defense attorney and the judge, ultimately they are treated with respect and empathy, and that they know that all of the people that I mentioned who are kind of part of that sexual assault response team, from the initial investigation to by law enforcement to the review of whether charges can be filed by my unit, that is done seriously with a goal of being able to go forward. And, that kind of respect and serious approach to every case is done regardless of someone's race or ethnicity, immigration status, gender identity, sexual orientation, social status. So that's kind of the aspirational expectations. And then for kind of the nitty-gritty process, it's kind of nitty-gritty. I mean, the criminal justice system it moves slowly. Obviously, due to the pandemic, there's now kind of a backlog of trials, and so I think it's even slower. But because sexual assault cases are serious cases, they generally take some time to reach a resolution when charges are filed. When cases initially come to our office to determine if charges can be filed, we try to complete that process quickly, and we have control over that. But once we file charges, we kind of lose some control over the timeline of how that case is going to move through the system. So, I think that victims should know that it is going to be a stressful process. For sure, it's not easy, but that there are multiple kind of resources, and you have a team of support working to help you through that process, whether it's counseling through the Victim Service Center with counselors who know that you have a pending criminal case, and they will help get you ready for the stress of having to testify at a deposition or testify at trial, to how my office communicates with you, which is always in as a team with the prosecutor and a victim advocate together, and keeping a victim informed every step of the way to say, okay, there's going to be this kind of hearing, this is what you can expect, preparing someone to give testimony at a deposition. And I guess the last thing is that, there is no guarantee of the outcome in a case. So that's a hard thing to say, okay, I'm signing up to be a witness in a case for this very personal and traumatic thing that happened to me, and I'm doing it without knowing what ultimately the resolution will be. But I think that the support of the prosecutor and the victim advocate and the Victim Service Center and a counselor can really help people with that kind of uncertainty.
Yeah, absolutely. And I do have a couple of follow-up questions as well. You mentioned the timeline, and I know that it's probably a little different now. And I also understand that it's probably different on individual cases. But just to have like an expectation for survivors out there that are deciding to go through the justice system, how long can this process take, and what can they expect as far as a timeline?
So from the date that maybe law enforcement starts investigating, let's say ultimately they make an arrest, that could happen very quickly, or that could take time because they have to wait for DNA results to come back, which could take 30, 60, 90 days, depending, or faster. But so from the time that my office gets the case, if an arrest was made, we would hopefully have a filing decision within about 3 weeks from the date the arrest was made. Like I said, we have control over the beginning, and so we try to work quickly.
I think generally a person could expect for that case to be pending for, let's say, about a year. But I will also say that because of the pandemic, and we're 9 months into it, things have slowed down a lot. And so there's a backlog of cases in the criminal justice system in the Ninth Circuit, in the state of Florida, in the country, in the world probably. So I think that kind of year could turn into more like a year and a half.
So having only done this particular type of prosecution in Florida, I can say that between Miami and kind of Orlando, it's pretty similar. But I can't say, other than kind of things that I've read or documentaries that I've seen about or prosecutors that I know who handle sex crimes cases around the country. I think that the things that I talked about are likely pretty similar, that I think criminal justice systems around the country are kind of bogged down with the number of cases that they have, and that prosecutors generally have a lot of cases. And if a person is represented by the public defender, they generally have a lot of cases. And so that contributes to like the timeline. I think that I would imagine, especially in like all kind of metropolitan areas, that state attorney's offices are structured where victim advocates work closely with prosecutors for a victim-centered approach, and that kind of some type of sexual assault response team exists in other kind of major metropolitan kind of cities where the goal is for a victim-centered approach to how cases are investigated and then prosecuted.
JoEllen, it sounds like going through the justice system can be quite stressful for a survivor of sexual violence for a variety of reasons. So how can victims deal with the stress, and how can a victim advocate from the VSC help a survivor navigate through the justice system, kind of how we were talking about earlier?
So it's really a great question. It's a good point, because I think most of the audience would be familiar with things we see on TV when it comes to Law and Order and CSI, and there's this media belief that everything is wrapped up and resolved in a rapid 42-minute episode. And that is definitely not the case. And sometimes I know many clients are asking, doesn't this happen tonight? Won't I know tonight if this happened? It's like, no, it's not going to happen that immediately. So basically the point I'm bringing up is really educating or re-educating individuals about the realities of what systems are facing and handling, and making individuals aware of understanding what their rights are, their specific rights, and some information about what the rights of defendants are as well. Because, we are a victim service center. We are absolutely focused on the victim perspective. But in the law, the defendant has rights, and there's timelines related to that. So we are not providing legal advice, just information that's, general knowledge information about what that may look like, what DNA, in terms of processing it and timelines and things of that sort. But here's what I want to say. Even as a professional, and I used to go to court all the time in New York dealing with family court, it was always butterflies in your stomach, anxiety provoking for someone who's been there, who is not talking about my own personal issues because of the way it's set up. It's very formal. There's a lot of individuals present. And so it can be confusing, it can be overwhelming, and it can be quite intimidating. So can you imagine how a victim who's already kind of rethinking and running the narrative in their mind about their experience constantly, whether they have, they're feeling issues of shame, let's talk about who the perpetrator was and their relationship to the perpetrator and what that dynamic looks like, and what that's going to be like during a trial if a trial comes out. So really, I think it's important to set expectations or provide information about expectations of what we can share with these victims, or for younger victims with their guardians or their loved ones. Ideas that we can do, or victim advocates from the state attorney's office, for example, maybe, taking the victim to the courthouse and just kind of letting them see what a courtroom may look like, where there's this understanding of, okay, so when they call me, I'm going to sit there. I'm not going to be next to my mom during this testimony. These are the places where maybe the defendant is going to be sitting. I think that's super informative, and just getting a sense of the environment and the space could be calming for individuals. I would say making connections and providing information is absolutely necessary. Any updates that our agency can get and provide to a victim on behalf of the victim is important, because being informed can ease some stress or anxiety in situations. I would also like to add, physically being there and being present as a support is something that an advocate from the Victim Service Center can do when it's appropriate and when it's requested and wanted by the victim. In some sometimes, the victim never gets that opportunity because a plea is decided upon. But in those occasions where it may go to trial, I've seen the joy from our staff and from the clients when it's been a successful prosecution. And there is, obviously, it's all about being for the victim and their success, but there is a sense of success and pride and joy that the staff here, the victim advocates here, feel because they've worked so hard with these victims who have really opened up and shared about the trauma. So it's lovely to kind of see when prosecution goes successfully, I'll say that. And then there's been plenty of times that advocates here have assisted in writing or assisted the victim in their victim impact statement, and kind of just, whether it's through journaling, prepping for kind of what that statement may look like and sound like, that's super important.
Yeah, absolutely. It sounds like kind of setting up those expectations and kind of easing that anxiety is so, so important. And speaking of which, I think a big source of anxiety for a victim might be having to face their perpetrator again. So what do you say to victims to help them feel prepared for this?
So I just want to bring up the fact that it really has to do a lot with the victim themselves in terms of emotionally how they're able to cope, intellectually, if there's any impairment, the relationship that this perpetrator may have to the victim. A stranger versus a family member is a very different dynamic in terms of being prepared for the moment of trial, or just prepared for the experience in life thereafter, with all family members kind of having their own opinions. I think it's important to think about the age of the victim and kind of when the victimization occurred, how recently, because this could have been something that was in the past that it's finally coming to trial. It could be repeated victimization. So those things are very, very vital to know and think about. And so I would hope that my staff and the victim advocates, who really are sexual counselors, that's what they do. I would hope that they are able to kind of take all the information that they know about the case and the victim and make a really good plan for the person to feel emotionally safe and ready when it comes to the trial. And it's almost like an emotional safety plan that they would do with the victim, and just kind of maybe some deep breathing techniques, some mindfulness or grounding techniques. Things like that may help individuals in a courtroom setting, especially when it's not the kind of setting where you can just walk up to the person and give them a hug. Like that's, to the victim and give them, that's not appropriate or allowed for. So there might be things like keeping a coin in their hand or a small rock and just kind of rubbing it if you feel, your heart is racing, or whatever those techniques may be, and they'll be individualized. And then ultimately it, just kind of letting the victim have the opportunity to kind of express their feelings, validate that those feelings are real. And it's expected that there should be common reactions to seeing their perpetrator. Not everybody can just go in stoic and just pretend that there is no impact on them emotionally. So it's okay to feel. I would say that's kind of the best way to handle that.
Absolutely. And I do have one last follow-up question about it. And Jenny, was there something you wanted to jump in on?
Yeah, just some of the things that JoEllen said really ring true. My unit prosecutes cases where children are victims, of course. And so we kind of routinely before a trial will take a child to the courtroom and show them the courtroom and let them sit in the witness stand and practice saying their name loud enough so that everyone can hear. And, I think any adult victim that we dealt with that was nervous about testifying, we would certainly do that as well. And it's always easy enough to find a courtroom that is not in use, and we just ask the court deputies at the courthouse to kind of let us into the courtroom. And so I think just what JoEllen was talking about, that, I think it's just with anything in life, anxiety is heightened when things are unknown. And so when we feel like we know what's coming, even if it's not something good, right? Like if you're a 4-year-old who has to get a shot, but you understand that it's coming and it's going to hurt, but it's going to be brief, maybe that can quell a kid's anxiety. And I think it's the same with adults and things that might essentially suck, like having to testify as the victim of a sexual assault and face your perpetrator. That I love the idea of what JoEllen said with an emotional safety plan. I think as the prosecutor and victim advocate, when we're working with a victim, we're constantly checking in with them on their mental health and emotional well-being to make sure that they're in a place where they're going to be able to handle and get through what's to come with the case. And, I can also just say kind of generally, like when a victim's going to testify in the courthouse, it is safe. There are court deputies in the courtroom. The defendant is not allowed to interact in any way, shape, or form with the victim from the moment they step foot into the courtroom to while they're testifying on the witness stand. We have investigators who work for our office who are law enforcement at the state attorney's office, and there have been times where we have an investigator assigned to our unit, and they have kind of accompanied a victim to the courtroom with the victim advocate if they felt uncomfortable. We've had service animals, dogs and a cat, accompany a victim, while they were waiting to testify. So there are a lot of kind of, like I said, resources available to make a person feel kind of as safe and as comfortable as they possibly can doing something that is going to be uncomfortable and hard.
Yeah, I think that's incredibly helpful to know kind of the resources that you have as a victim and a survivor, but also kind of the rights that you have, and understanding that the defendant can't talk to them or approach them. That's really helpful to know. So
yeah, like they can't even make faces while the victim is testifying. Like it's really be allowed. So
it has to be neutral. Got it. That makes a lot of sense.
Yeah.
I wanted to ask this, and this can be a question for both you, JoEllen, and you, Jenny. We're talking a lot about, the stress of going to court in general. In your opinion, is the stress that survivors of sexual assault face while going through the justice system different for victims of other crimes?
I think that it probably is different. I don't want to quantify people's trauma, but like I said at the outset, I think that sex crimes are different because they involve sex, right? And so I think that kind of trauma is on display almost when it's a jury trial and a victim is having to talk about a sexual assault. So I do think it's different. And there are, actually now's a good time to mention, there are a few other protections that exist precisely for this reason. So victims of sexual assault can elect to limit the number of people in the courtroom while the victim is testifying. So this is a law in Florida, and obviously there are essential people who will remain in the courtroom: the judge, the clerk, the court reporter, the deputies, the jury, the defendant, their counsel, the prosecutor. But when a victim makes this election, they are essentially clearing the courtroom of everyone else. Not the defendant's immediate family. The defendant's immediate family will be allowed to remain. But the general public who maybe had an interest in the case and wanted to sit and watch the trial, they would not be allowed to just, be spectators. But the victim does get to elect to have a victim advocate present in the courtroom with them as well, even though they're clearing the courtroom of all the other kind of non-essential people. And so that is a specific right for victims of sexual assault. And if it's a child testifying, it is an automatic thing that kicks in. If it's an adult, it's at the election of the adult victim. So, yeah, I mean, I think it's not just me who kind of looks at these cases differently. I think the legislature with certain laws recognizes that the experience of a victim of sexual assault in the criminal justice system is different and deserves additional protections.
And I would just add to that. I think that was an excellent point that you brought up in terms of the election to have individuals removed from the court. Great point, Jenny. I would add that when it comes to individuals, perhaps members of the LGBTQ community, if their assault was something like haven't already disclosed their identity in terms of, maybe being a gay male, and suddenly there was a sexual assault, there's a further disclosure that's happening. So why I think things are even more different for sexual assault victims is because of levels of intimacy, disclosure, issues of shame. If there's already a pre-existing relationship with the person who assaulted them, are their past relationship issues going to come up? So concept of airing dirty laundry, people don't necessarily want to do that. And I think people who are victims may trip themselves up emotionally thinking everything's going to be on display. And it really isn't, because the prosecution very much is skilled in navigating that. But there's a lot of things that could be rooted in shame issues that could come out in a trial.
And JoEllen, what you just talked about, right? Like prosecutors who are skilled in navigating those issues, right? There are additional laws that also protect victims of sexual assault from kind of what you were talking about, JoEllen, like having their whole life be an open book, so that there is a specific law to protect from that happening, where a person's otherwise consensual sexual life is protected and generally does not become a part of the criminal case because it wouldn't be relevant. So that is another protection. And also in terms of kind of maybe safety ideas, there are also protections about being able to keep confidential a victim's address and contact information, and maybe even being able to, in written reports that are disclosed to the defense attorney and then perhaps to the defendant, only using initials in written documents. And the clerk's office, if they have documents that are public on their website, they would redact completely the victim's identity and name and identifying information. So that's something else that I wanted to make sure that people know, is that steps are taken by the state attorney's office, by the clerk, to keep identity and contact information confidential when that's an appropriate and kind of necessary step. And then as the prosecutors, we can always file additional motions to have a judge make rulings for additional protections for victims that are needed.
That's a great point. So you're saying there's already kind of a precedent or a standard in terms of protecting certain information through redaction, but then there's heightened opportunity maybe for additional protections. That's a really good point. Thank you for bringing that up.
Yes, you're welcome.
And kind of shifting the conversation just a little bit here, Jenny, why are some cases not picked up by the state attorney's office?
So cases that come to us come through law enforcement, either because the police made an arrest or they got a warrant, and that automatically comes to us, or because they are filing charges directly with my office. So cases like that, they probably feel like they have met their burden to file charges with us, but it may not be a case with a lot of evidence, so they did not make an arrest or get a warrant, and they want us to review and investigate and defer to us to make a decision about whether we can go forward and file charges. And so if law enforcement sends the case over to us in one of those two ways, then we're going to undertake the same analysis, which is, can we prove this case beyond a reasonable doubt? And like I talked about before, it's a very high burden. And unfortunately, there are a lot of cases where we believe the victim 100% about what happened, but we are left without the evidence where we would be able to prove beyond a reasonable doubt to a jury that the defendant is guilty of that crime. So that's essentially the reason why some cases are filed by us and some cases aren't.
Got it. And going off of that, you talked about like a jury and such. So why do some trials go in front of a jury and why do some only go in front of a judge?
So defendants, any person charged with a crime, has the right to a jury trial. The criminal justice system generally kind of relies on a very large percentage of cases resolving with what's called a plea. So a plea of guilty or a plea of no contest, where the sentence for that person is kind of negotiated between the prosecutor and the defense attorney and then brought to the judge. And if the judge accepts that sentence, then the judge will impose that sentence after the defendant enters that guilty plea. And that happens in a majority of cases because not every defendant wants to take the risk of going to trial. Ultimately, it's the defendant's choice whether they are going to engage in plea negotiations, accept a plea offer, a resolution that's been negotiated by the prosecutor and the attorney representing them. But the victim in our cases and sex crimes cases plays a pretty major role in how we're going to figure out the direction of a case. So, well, like JoEllen mentioned before, we represent the state of Florida. We are not the attorney for the victim, but we are, first of all, obligated to have discussions with the victim about any potential plea offer kind of resolution, but also we value the input of the victim. And like JoEllen mentioned, we may end up on a different page than the victim. Ultimately, maybe the victim wanted a plea offer that was a term of years in prison that is greater than what we're ultimately going to do, or is less than what we're ultimately going to do, or they wanted just a different resolution. But we try to end up in the ballpark so that they are, I guess, satisfied with the ultimate resolution in a case. And I think when we were talking about kind of the emotional well-being of a victim and how a trial could potentially affect them, that could be something that we take into account where, maybe it's been a year and a half or 2 years and the case is now ready for trial and a victim is giving us input about wanting the case to resolve with a plea because they don't feel like they are in a place where they can emotionally handle testifying. And so we would certainly take that into account as well. Because as I mentioned, I think we try to take a very victim-centered approach. So that's kind of, I guess, why not every case is going to go to trial. And like I said, ultimately it's the defendant's choice. If the defendant says, I don't want to accept any responsibility, I'm not admitting my guilt in any way, I want to go to trial, then, in all likelihood, that case would just go to trial. Otherwise, the plea is just taken before a judge, but that victim impact statement can be given at the sentencing after a trial, assuming it's a guilty verdict, or at the sentencing after a defendant enters a plea of guilty.
Got it. And that kind of leads to my other question where we were talking about, that satisfaction that you were talking about. Because, on this podcast, we talk about a lot how everyone's healing journey looks different. So, JoEllen, I wanted to ask if you believe going through the justice system is an important step towards healing.
So probably on each of the podcasts that I've been on, I probably had this little mantra regarding that, criminal justice does not equal closure. It is an avenue for victims. It's a possibility for victims, but it is not necessarily the be all and end all. And so we believe that people are on a healing journey and they're looking for closure emotionally through their own healing. And so I definitely always have to say, everything could be set up perfectly in terms of a case going the right way for a victim. First, the unfortunate victimization happens, but from there, police believe them, their perpetrator was located, the state attorney's office picked up the charges, the case moved forward. Everything looks like it's going in a direction that the victim may want, but jury makes a different decision. Or even if jury makes a decision to prosecute, the sentence is lower than expectations. Those factors are such uncontrollable issues for a victim. And so we know about sexual violence, that power and control. And when you think about loss of control, it can kind of be an unraveling again for a victim. So absolutely, every victim has to decide for themselves. They have to be educated and informed to understand what the options are and what their rights are. But the reality that not everything may work out in the way that they hope or want. And so we try to focus on what it is that they look for in terms of emotionally being able to overcome, where they're going from an individual who is a victim to an individual who's a survivor, and then ultimately a thriver, where they're living their life and they're putting this in the past and they're either reflecting on it or able to talk about it or however they cope with it. So for us, that's really what our focus is, because we encounter victims who have been recently victimized through the acute process. We're collecting DNA, and those who are, 20 years plus dealing with kind of a victimization that they've never actually talked about. And it is difficult for individuals, but once they have a space that's safe, where there's a professional support system and even some peer support systems through our Speakers Bureau, it is an opportunity to kind of grow as an individual and accept certain things. I've seen individuals where they've never went through the criminal justice system and they were able to work on their healing, and then suddenly maybe the perpetrator passes away and it changes the dynamic of their life. There's some more hopefulness and some hopelessness that they never got to confront that person. So I would say for me, individually, the person has to kind of decide what they want to do, and we can just guide and navigate and offer options through that process.
Definitely. I think that word closure that you mentioned, JoEllen, is a difficult one, but it sounds like once again the VSC is able to kind of have that individualistic approach and also letting the survivor drive that bus, I like to say, and then having that victim advocate and other people in the community as a support to help guide them. But once again, that power is still remaining with the survivor, which is so important. Jenny, I think that the system can be fairly complicated. We've been talking a lot and there's still so much to talk about. And results in many misconceptions. And one of those misconceptions could be that if someone is not found guilty, that the crime did not occur or happen. So could you speak to this a bit?
Yeah. There is a very big difference between somebody being found not guilty and saying that they are innocent. And I think even a defense attorney is not arguing necessarily. They might be, but they don't have to argue that their client is innocent. really what a trial is about is, has the state proven its case? Has the state, through witnesses testifying and through whatever evidence they have, met its burden that this crime was committed by the defendant beyond a reasonable doubt? So, sometimes defense attorneys in a closing argument might just say the state didn't meet its burden. You can't find my client guilty because there's reasonable doubt about this issue, and there's reasonable doubt about this issue, and there's reasonable doubt about this issue. Maybe something happened, but we just don't really know what happened. So the state did not meet its burden. Maybe they get up there and say, none of this happened. My client's completely innocent. But I think that if a jury checks the box of not guilty, by no means, maybe they go home and they feel like, I feel like it happened, but I couldn't say beyond and to the exclusion of every reasonable doubt that it happened. Maybe if you asked the jury, they would say, no, this person's not innocent, but I just didn't feel like I had enough evidence to convict them. So I think maybe there are like some big high profile cases that we could think about where somebody was actually innocent, or, obviously there are people who have been wrongly convicted and who are exonerated. There are wonderful documentaries you can watch about this to kind of see how horrible it can be for a person when the criminal justice system just gets it wrong, and people maybe are blind to other things and somebody is wrongfully convicted. But a not guilty verdict is just very different than somebody being innocent of a crime. And, whenever a victim is going to testify, part of our prep will be that the outcome of this case has nothing to do with your strength in being able to get in front of a jury in a courtroom of a judge and all these strangers and talk about what happened to you and do it in front of your perpetrator. And that, the jury's ultimate verdict is not a referendum on whether they believe you. And so I think that's a really hard thing. But that's a misconception. I think maybe another misconception is that, every sexual assault case is going to have forensic evidence to support it. And, there are times where we go to trial and juries convict based solely off of the testimony of the victim. And that's the only evidence, right? That has to be kind of detailed and compelling testimony. But that alone can be enough for a jury to find that the state has met its burden.
Definitely. Thanks for breaking that down. I think that that's really important information to share. JoEllen, it sounds like a big decision for a survivor is to decide to go through the justice system. That being said, how can a survivor know if this is the right path for them to take, and how can the VSC help support a survivor in making that decision?
I mean, it's completely an individual's decision, honestly. I mean, here's the thing, like we started to talk about earlier, and I don't know, Jenny, maybe you can speak to this, but once you're presented with details of a case, if that victim chooses to back out in terms of being involved, that doesn't mean that it's like, we're not going to pursue this. It could be a very serious case, and the state has to do what they have to do.
Definitely.
So I would definitely want you to elaborate on that, because I don't know how frequently that happens, but I know that there are times that victims kind of, they do decide after some time they rather not continue, and that's an individual decision. But I wouldn't want to kind of say that our agency is going to provide any advice on that, because that's a personal decision. I mean, first of all, just disclosing it is very powerful in itself. And being able to say this happened to me, and most importantly, being believed, is the most crucial thing we can hope for. But then after disclosing it, making a choice to bring it to law enforcement is important, and it's an option. Obviously, if we're aware of information and we're mandated reporters, we will have to act on that beyond what maybe someone who doesn't want that to happen would expect, but if we're mandated in a situation, we will. But then moving forward with prosecution and, declining to prosecute, those kind of things are all an individual's choice. But that's a curious question, Jenny. How frequently, if at all, do cases come to the state attorney's office that, prosecution makes the decision, we're going to move forward, when a victim is like, hey, I'm kind of bowing out?
Yeah, I mean, so it does happen. And in terms of our ultimate decision of, well, there would be, it's just very kind of fact and circumstance specific, but perhaps it's possible that we have enough other evidence that we can still go forward with a case without that victim. I think that's rarer in adult cases than in cases involving children. But I think that our goal would be to have, a meaningful conversation with that victim about where they're coming from and what they're going through, and if there are more resources or help that could help them stay cooperative. And, I think that at the forefront of our minds as we're prosecuting a case is right, we have to do justice. We have to make sure that we're going to keep the community safe, but really we want to make sure that the victim that in the case, that their kind of well-being is okay, that their emotional health is being protected. We wouldn't want somebody to be in a position where if they're going to testify, their world is going to come crashing down, and they will be a harm to themselves or something like that. So we would just want to have a meaningful conversation and then really figure out if we need to have them testify despite their wishes, because that's what is required for the safety of the community. And, if that ultimately were the decision that were made, we would do everything that we could to make the experience as absolutely tolerable as possible, and may work with you guys at the VSC, JoEllen, about, about what support and additional support we can provide for that person.
As a final question to you, Jenny, are there any changes that you have seen in regards to sex crimes and how they are processed in the judicial system?
Yeah, I mean, I think nationally and within the state and within our counties, definitely a victim-centered approach. I think that there is a campaign amongst law enforcement called Start by Believing. There are new, what JoEllen was talking about kind of the neurobiology of trauma. That's something that's being taught to detectives so that they understand that there are ways to relate to victims of trauma and ways to ask questions about an assault that are not what happened first, what happened next, because there are things that kind of happen in the brain and the nervous system when a person's going through trauma that cause the kind of sequential ordering of events. That part of the brain kind of shuts down, and the more sensory and experience recording part of the brain, I think, if I'm getting this right, is at the forefront. And so there's a way of interviewing called the Forensic Experiential Trauma Interviewing Technique, FETI. And so there are kind of detectives and investigators who are being trained in following that model to obtain information. There have been, so I think that's one area. And then, there are kind of, I guess, scientific advances with DNA. There's more sensitivity to tests where we're able to get more information from DNA than even kind of 5 years ago. It's becoming more mainstream, certainly than 10 years ago. So those, and then I think kind of legislatively, maybe every kind of year, there are laws that are being passed to expand protections for victims of sexual assault and sexual abuse, whether it's enlarging statute of limitations for crimes to be prosecuted, other protections. So I think that everyone is headed in that direction.
And going off of that, what are some changes that you would actually like to see?
Yeah, I think it just dovetails off of a victim-centered approach, but it would kind of be a more trauma-informed justice system in general. So obviously, law enforcement is on the side of victims, and my office is, but for defense attorneys to have training on the trauma that victims have gone through, for judges to have that training so that, everyone understands how their interactions with a victim in a criminal case are going to affect that victim beyond that day and that interaction. I think that, from the Me Too movement and lots of kind of ways to be informed about sexual assault for the general public, whether it's through documentaries or shows or movies and kind of high profile trials or cases like the Bill Cosby case and Harvey Weinstein and the U.S. gymnastics trainer Larry Nassar, that those have all kind of brought a good change in people's perception about who can be victims and, the strength of victims. And, I think for that, well, one concrete thing I can mention that I would like to see is with the pandemic, we do so many things virtually now that, hearings and depositions of victims have largely been done virtually. I would like to see that continue after the pandemic for victim depots to be able to continue in a virtual format, because I think that is something from the feedback we've gotten that makes the experience easier for victims. But I think that the sentencing that took place in the U.S. gymnastics Larry Nassar case, so he entered a plea and then the judge did a sentencing hearing where I think it took a week because hundreds of gymnasts testified at a sentencing and gave impact statements. And I think that hearing is like a model for how a trauma-informed, victim-centered approach to sexual assault cases in the criminal justice system could be, because the defendant, Nassar, was in the witness stand. And so when these women came up to the lectern and were speaking to the judge about how his abuse and assault of them affected them, he was facing them and they were able to talk to him and to the judge. And the respect and empathy and admiration with which the judge treated those victims was incredible and admirable. And I would love to see that approach throughout every courthouse in this country.
Awesome. Thank you for sharing all of that great information. I think that's a great place to sign off. Before we do, is there anything you, Jen, or you, JoEllen, would like to address in regards to sexual assault in the justice system? Or is there anything specific you'd like to say to an attorney or a survivor before we sign off?
I just wanted to say that's a great way to end with that kind of powerful, hopeful, optimistic kind of what the future could be for all victims. And I just want to say thank you to Jenny, because it's great to work with such supportive, strong, and, just skilled partners that really kind of constantly make sure everyone that's involved with victims and the criminal justice system is doing everything they can in a professional, respectful manner. So it's great working with you.
Oh, JoEllen, and I feel the same way about you. So thank you.
Awesome. I love it. And, I just want to thank you both and also thank the listener for listening to the Victim Service Center podcast. The VSC is a nonprofit organization that provides free, confidential counseling services for victims of any kind of trauma in Central Florida. To learn more about our services, please visit victimservicecenter.org. And to everyone listening, healing is not linear. You are not alone. And thank you once again, Jenny and JoEllen, for joining me today.
Thank you so much for having me, Emilie.